Welcome back. You're watching CNN News 18. I'm Griha Atul Siddiqui. We're talking about the 3-2 verdict that's come out of the Supreme Court regarding EWS quota. And while the apex court of the country has upheld the EWS quota, Congress's Udit Raj has hit out at the very court and called the top court of the country as casteist. He has tweeted out, let me quote him here, Supreme Court is casteist, still no doubt. When it came to EWS reservation, it was preserved and the 50% limit also was not treated as a constitutional obligation. But whenever it came to giving reservation to SC, ST and OBCs or the economically backward classes of the society, the 50% limit in the Indra Sahni case was always cited. My colleague Shireen Elizabeth is joining us on the broadcast. Shireen, a voice, very strong one at that when it comes to the Congress. However, the Congress party did not go ahead and challenge this very, verdict that's come out, and they did not have any problems when it was actually brought about by the government at the center. So why this word by Udit Raj?
Well, Udit Raj is in fact someone who is known to be a voice for the SC/ST community. He is in fact the member of the SC/ST department also. He has never been shied away from talking on these issues. And we have seen that he has always taken lines which are in fact very different from what the party's line is. And today he has made a very big accusation on the EWS verdict by the Supreme Court, calling the Supreme Court as a casteist. He has in fact went on to say how the EWS reservation doesn't seem to be a big issue for the Supreme Court. They say that this can be in fact flexible, but when it comes to the SC/ST reservation, they always had issues. They always had problems that how it can cross the 50% of the reservation is something that has been an issue for them. So clearly, this accusation that is coming, the big claim that is coming from Udit Raj, he in fact, has always taken a different stand because like you mentioned, whenever we talk about the EWS, the Congress has never really openly made any kind of statement. They have always agreed with the 10% EWS that was in fact released by the government in 2019. They have never taken any stand against it. But Udit Raj making this claim, of course, but he is also known to be someone who takes a different stand. So if this is his individual stand or is it the party's stand is something that has to be clarified. But a big claim calling Supreme Court.
Absolutely. So let me actually take this across to Mr. Ashpreet of the Congress. Mr. Ashpreet, the fact that there is another dissenting and a very strong argument at that coming in from Udit Raj, how does the party now choose to respond to something like this?
Well, since we are discussing dissent and since we are discussing, different things that are apart from the judgment, the Bharatiya Janata Party otherwise is in favor of the economically weaker section. But considering the flats that are being delayed by 6 years, that the Congress Party, a project that the Congress Party had brought in, the Bharatiya Janata Party did it, and 68% was not being able to deliver on their promise. This goes on to suggest that the Bharatiya Janata Party blows hot and cold at the same time. On one side, they say we are in favor of the EWS. On the other side, they do not want to build flats for the EWS. Number two, with regards to the EWS stand of the Congress Party, I think it's important to mention that it was Rajiv Gandhi ji, P.V. Narasimha Rao ji, Manmohan Singh ji that had paved the way for the EWS quota and had laid the groundwork. This has to be taken into account. This has to be taken into consideration because the Bharatiya Janata Party, some leaders say yes, some leaders say no, but we have always been in favor of the EWS quota, and we hope that the Bharatiya Janata Party would also deliver upon their flats. As far as the judgment is considered and concerned, it's a historic step. We're looking forward to it, and we hope that it would bring, reprieve and relief to the economically weaker section of India.
Okay, sometimes, neutrality also augurs to the line of confusion. Mr. Singh, let me actually take this to Tom Varakan of the BJP, who's also joining us on the broadcast. Mr. Varakan, the fact that there is one tweet that has come out accusing the Supreme Court, the apex court of the country, of casteism, that's come out from the member of the Congress Party. Congress Party, on the other hand, is also going ahead making it a political issue. Of course it is. However, they are sort of not denying completely on what Udit Raj has stated when it comes to the economically weaker sections, economically backward sections of the society, so to speak, SC, STs, OBCs, etc.
this is a typical double speak of the Congress party. They want to be on both sides. Whichever win they would join. They said, well, EWS was launched by them and what have you, and that the judgment was part of the gains that they have achieved. Be what it may. Yes, it is a decision taken by the Supreme Court. We welcome it. We will comment properly on this after reading the judgment, because I think it's a little premature and will be injustice to the Honorable Court without having read the judgment properly to make comments. And I strongly condemn the statement of that gentleman from the Congress who has already tweeted without having read. I can assure you he has not read the judgment yet and has gone on public record. This is basically a person who is,
The Supreme Court has upheld the 10% EWS quota that was announced by the Modi government just a few months ago. To talk more on this, I am being joined by Senior Congress leader Udit Raj. Sir, how do you see this verdict that has come in from the Supreme Court, where the Supreme Court has said that it does not infringe the Constitution when 10% extra quota is given to the economical weaker sections?
See, I don't oppose EWS reservation given to poor upper caste. But I definitely oppose the mindset of the Supreme Court. Ever since Indira Sahni judgment, that is popularly known as the Mandal judgment, Supreme Court has been always rejecting whenever the limit of reservation exceeded in the matter of SC, ST, OBC, that there is a ceiling limit imposed by Indira Sahni case, and a reservation in any case cannot exceed more than 50%. But today the same Supreme Court says that Constitution doesn't bar it. Isn't it the mindset of the Supreme Court that the biased mindset? Whenever it comes to the SC, ST, OBC, they have a different yardstick, and when it comes to the general category, has a different stand. So I make allegation, I stand by it, that the same Supreme Court has been repeatedly saying that limit cannot be crossed. That limit is 50%. That is what I have said.
Sir, you had also put out a tweet just a few months ago where you have called the Supreme Court casteist. Why have you put out this tweet, sir?
I said. Why
do you think so that the Supreme Court is casteist?
Yes,
when the judge...
I have given the logic. If there is anybody to contradict my logic, I stand. I'm ready to debate. In fact, why all the judgments so far have been judgments of Supreme Court that the limit cannot exceed. Ceiling imposed was 50%, which cannot be exceeded. But today the same Supreme Court interpreting that the Supreme Court, that Constitution doesn't bar. What is this? That is mindset.
Right, sir. Also, we have seen the manner in which the politics has happened around it. People are already, you in fact have already raised question on this. But yes, the Supreme Court has also said that EWS section will belong to the general category. So do you also oppose this? That the
the ideal situation would have been that in EWS, entire population would have been covered.
Right.
That would have been ideal position.
So do you think this is a biased mentality of the Supreme Court that is coming out right now?
Exactly. I said it. I stand by it.
So are you planning to take any action, or do you plan to challenge it?
In a democracy, what action? Supreme Court is Supreme Court, no action, but is my views which I express, and that is correct, and that based on the facts.
Right, sir. Thank you so much for your time. So that was Senior Congress leader Udit Raj speaking to CNN News 18, where he has said that the mindset of Supreme Court is exposed when the 10% extra quota is given to the EWS section, when according to the Indira Sahni government, the 50% quota was the upper limit. What remains to be seen, how much more politics can happen around this entire case. Till then, the entire...
The counsel for the petitioner. Shadan sir, how do you see this verdict? First of all, 3:2 ratio coming in, dissenting voices, Justice Ravindra Bhat and Chief Justice of India, Justice Dinesh Maheshwari.
Yeah, this is an interesting view in the sense that there are two very different visions of the Constitution envisaged by the two sets of judges. The majority view effectively sees reservation as something which was, and they have emphasized that towards the end of their view, that something temporary and should have been, it's a time to regularly reconsider that. Whereas the dissent quite clearly sees that this is a mechanism for substantive justice, and therefore the exclusion of the backward classes, SC, STs and OBCs from this EWS category, they have found it to be violative of basic structure.
Another question that arises is that Attorney General K.K. Venugopal, who was the then Attorney General, had argued that the SC, ST, OBCs cannot actually claim this benefit because they are already loaded with benefits. So, do you think that argument has somewhere or the other been accepted by the bench?
See, I will have to read, if specifically that argument has been accepted, I'll have to read the opinions, which are yet not, none of us have read it because it's not yet out. But let's assume that has been accepted, but obviously the dissent has not accepted that argument, right? Because the dissent has seen that in fact, and we showed that to the court, that the poorest are ones who belong to OBCs and SC, ST. So even if you remove caste completely, you just look at economic criteria, you are trying to benefit the poor. But in that poor, if 70-80% are from backward classes, you're excluding them, then what's the purpose of this amendment? It's only part good. And that is the argument which two judges have accepted.
Second last question before I let you go is that a very important, in fact, observation came in from Justice Bela M Trivedi and also by one of the other judges who was concurring this opinion, is that the reservation system has to be re-looked into, and it should not be made that it's a vested interest. How do you see that?
See, that is from a formal equality perspective, I can see that what the point is being made. But the problem with that is on the ground. Do you have today enough people from backward classes who are there in government services? Do you have enough people from SC, STs who are there in government services? There are 80 secretaries to the government of India. Not more than 1 or 2 will be from the backward classes, SC, STs or OBCs. So you can finish off reservations, no difficulty, once you have genuine equality. But today, is there genuine equality on the ground despite reservations? The answer is no. Therefore, you have to further work much harder to get that first. If you get that stage first, then yes, remove it. But we are nowhere close to that yet. So therefore, this repetition, constant repetition that it's time bound, that doesn't help because the objective has not been met. You first meet the objective, then remove it, no difficulty. But there's a long way to go for objective being met. That's the point.
So this was Advocate Shadan Farasat who was speaking to us. He was one of the petitioners. But a very, very important question that I would also like to throw to Mr. Swapnil Kothari is that we've heard Justice Bela M Trivedi, we've heard Justice Pardiwala saying a very similar aspect is that reservation system has to be re-looked into because we are already into 75 years of independence. Another part that Justice Pardiwala said is that the reservation system shall be re-looked into so that there is no kind of a re-invasion or there has to be somewhere or the other a re-look into it. How do you see, Mr. Kothari, this observation coming in from the two judges?
Well, Ananya, the two judges have sounded out a cautionary note that today, as of this day, looking at the circumstances, we are passing on this amendment. We have no reservation or we have no hesitation and no difficulty in that. But on another day, maybe 5 years, 10 years down the road, if we are there or if our successors are there, they'll look at it differently and they'll throw this out saying that it is violative because all the time you cannot have reservations because if the objectives are not being met, with these reservations and with these quota business, then obviously somewhere the reservations are not doing the job. And we have to look at the practicality of it, the fruition of it. In the sense that what the judges are trying to say is that looking at purely from the prism of constitutionality and transformative constitution, the 103rd Amendment is beautiful, it is sublime, and we need to pass it. But when you look at actual results of the reservations that have been there in the past and whether the objectives of those reservations have been met or not, whether the really backward sections of the society, and I'm not talking EW, I'm talking of the backward sections. The EW has been passed today. But the backward sections of the society, whether they have really come up shoulder to shoulder with you and me, whether that has really taken place or not, that is something which needs to be taken a look at. And if we find that the results are not really appetizing or satisfactory, then we do not believe in this quota business. We do not believe in this reservation system. We will not pass this in the future. Somewhere there has to be a time span. We have to look at the results of it. And that's exactly what they are hinting at. They're telling the government that so far so good, we are with you. But maybe a couple of years down the road, we'll sit along with Justice Ravindra Bhat and the CJI U.U. Lalit on this.
Swapnil, before I let you go, and this is adding to the point that Ananya was also making, before we wrap this, adding to the earlier argument of the Bundle Commission that you brought in, the fact that quota was not meant for an indefinite time. It is actually for the upliftment of a certain community. Once it attains that level playing field or the genuine equality is when they should be removed. However, do you think this re-looking at quota, which Ananya also was talking about, has been not done at all, and there is a sense of complacency, and because of which these arguments of quota after quota is being brought forth, and this is much as a general sense that I'm talking about, do you think that needs to be looked at more intrinsically?
Yes, definitely, Griha. That is a fantastic question. And in fact, that is what I believe, that the government somewhere must have shielded this or must have put it in such a way. So I'm not saying that the government has duped the Supreme Court. What I'm trying to say is that the government has tried to put up a picture saying that in as much as we try to bring in the weaker sections of the society, and I do not mean EWS, I mean the backward people, on par with the advanced sections. It's still a pipe dream. It's still not something which is going to be achieved within a short period of time, because we are a billion people, and it's going to take a while. So the picture that they have presented to the court, and I'm sure that must have been forming part of their arguments, is that there is an upliftment. These sections of society have come in. Look at these people who have occupied the top positions in society, and it's going to take a while. And so far, so good. The Supreme Court would have said, all right, we buy this argument. Let's go ahead with this. On its whole, the 103rd Amendment has a noble objective. So we cannot discount it or we cannot bypass it. And look at the brilliance of the people who've drafted the 103rd Amendment. It's so short. It's so precise. It's put in so little words that there is very little room for any negative lawyer or any contrarian lawyer to poke holes into it and say that, look, this is going against the basic structure or anything of that sort. Because ultimately, when you have to argue before the Supreme Court, apart from the fruits of it, that's a separate argument, whether something has achieved fruits or not. That the Supreme Court will say, sorry, that's for the government to decide, and that's for the people of the day to administer and implement. But when we look at it, we have to look at it from the constitutional prism. But that will change soon. Absolutely. Eventually, after some time, the Supreme Court will get more and more progressive, Griha, and they're going to get into that part more so than the sublime nature of our constitution, or those broad, utopian ideals and, brilliant views and the gargantuan ideas that people have. That all looks very flowery and beautiful. But when it's on the grassroots, it doesn't cut ice.
Absolutely.
That's what the Supreme Court is saying.
Absolutely. Swapnil Kothari, thank you so much. And on that positive note, I'd like to take a break. This is a very, very important development that's come out of the apex court of the country, a 3:2 judgment where it has been underlined by the Supreme Court of the country that the EWS quota is not violative of the basic structure of the Constitution. Slipping into a very short break, coming right back with more news and updates. Stay tuned.